Indonesia's legal system grapples with the complex intersection of tax law, known as UU KUP, and corruption law, referred to as UU Tipikor. These laws, while intended to work in tandem, often present conflicting interpretations, particularly when dealing with the concept of harm to state finances. This essay will delve into the nuances of these laws, focusing on how tax violations can be perceived as acts of corruption. We will also explore the limitations of restorative justice, or RJ, in corruption cases and highlight the contradictions within the KUP law itself. Understanding the differences between formal and material offences is crucial in navigating this complex legal landscape. We will examine how these definitions apply to tax violations and whether potential harm to state revenue is sufficient to warrant corruption charges. The essay will further analyze the controversial Article 44B of the KUP law, which allows for the cessation of investigations if tax debts and fines are settled. This provision seemingly contradicts the corruption law's stance on RJ, raising questions about its applicability in cases where tax violations are considered acts of corruption. The crux of the issue lies in differentiating between formal and material offences. Formal offences, as defined by Indonesian law, are acts deemed illegal regardless of their consequences. Material offences, on the other hand, require demonstrable harm to be considered criminal. Articles 38 and 39 of the KUP law seem to categorise tax violations as formal offences, implying that the mere potential for revenue loss is sufficient for prosecution. However, the Constitutional Court's interpretation of corruption cases leans towards a material offence approach. This perspective necessitates actual quantifiable harm to state finances for corruption charges to be brought forth. This discrepancy creates ambiguity when tax violations are evaluated through the lens of corruption, leaving room for debate on whether potential harm is enough to warrant such charges. The Indonesian legal system acknowledges that tax violations, under certain circumstances, can constitute acts of corruption. This is particularly relevant when the substance over form doctrine is applied. This doctrine prioritizes the economic reality of a transaction over its legal form. Therefore, if the core intention behind a financial transaction is to evade tax obligations and thereby harm state finances, it can be classified as corruption, regardless of its legality under tax law. This interpretation underscores the importance of examining the intent and actual economic impact of financial transactions when evaluating potential corruption cases. The KUP law itself presents internal contradictions that further complicate the issue. Article 44B, while seemingly offering a mechanism for resolving tax disputes, clashes with the principles of the corruption law. The provision allows for the Minister of Finance to halt investigations if outstanding tax liabilities are settled, resembling a form of RJ. However, the corruption law expressly forbids RJ in corruption cases, maintaining that recovering state funds does not absolve the act of corruption itself. This stark contrast highlights the need for greater clarity and harmonization within the Indonesian legal framework. The Indonesian legal system is in dire need of clearer guidelines and consistent application of the law, particularly concerning the classification of tax violations and the applicability of RJ. The lack of clarity not only creates confusion but also undermines the principles of fairness and justice that the law strives to uphold.